the first type of client we have, or it might even be you personally, is one who is thinking about, hey, maybe I might get married. That is a person who also might get divorced. The first most important thing, bullet number 1 right here, if you learn nothing else and you're an estate planner on this call today, look at your documents and look at how you're defining the term spouse. Prenups are great. We should absolutely be doing prenups for especially our high net worth or ultra high net worth clients.
Welcome, and thank you for joining us for another Justia webinar. My name is Nina, and I'll be the moderator for today. Now, to kick things off, I want to go ahead and introduce our speaker, Stacey M. Valentine. Stacey M. Valentine is a partner at Avellino Law LLP, working with A. Jude Avellino to lead the Trust and Estates Practice Group. A graduate of Colgate University and Washington and Lee University School of Law, Ms. Valentine leverages her extensive experience in analyzing, structuring, and administering sophisticated estate plans to assist individuals and families in achieving their wealth planning goals. In an intricate and ever-changing complex area of the law, clients can not only appreciate her vast knowledge, but also her ability to communicate clearly and plainly, avoiding overwhelming jargon. She makes the entire planning process straightforward and works tirelessly with her clients to understand the implications of the plans they set in place. With that in mind, the webinar that you're about to watch will be about 1 hour, and Stacey will be taking questions from the audience at the end of the presentation. So if you have any questions that come up that you'd like us to address later on, you can always submit them by clicking the Q&A button in the control panel at the bottom of your screen and sending them in there. Now, without further ado, here is Stacey to discuss where estate planning meets family law, strategies for complex divorce clients.
Thanks so much, Nina. Nice to see everyone today. Like Nina said, I will definitely leave time for questions at the end. I would like to pretend I'm tech savvy enough to somehow manage my PowerPoint and push the Q&A button, and it's just not true. So let's be aware of our limitations. So I'm going to try to keep the questions for the end so that I don't somehow mess up all of our tech abilities here. So as Nina mentioned, I'm a partner with Avellino Law. I've been in the trust. Just for you guys, you can internet stalk me and figure that out if you must. But suffice it to say, I've been doing this a long time. And I found that one of the areas that I spend a lot of my practice in is this overlap between estate planning and family law. How did that happen? I'm not 100% sure. My first exposure to the family law world was on a personal level. And I think once that happened, my clients just naturally reached out to me when they were going through the same experience. And so time and time again, I started getting questions about how estate planning and family law overlap. What would this mean for the client? What could the client do? What options are there out there? And so I kind of just fell into this little niche of the law where there are not many folks who dare to tread, right? Because most of us want to stay in our lane, which is what we should do. That's a great idea, generally speaking. And so these two practice areas, although they have a lot of overlap, really do require two very different specialties, for lack of a better word. Now, let me be clear. I am not a family law attorney. Don't pretend to be one. If you called me and said, Stacey, you seem great, please be my divorce attorney, I will hook you up with a great divorce attorney, but it shall not be me. My role is to coordinate with divorce attorneys and be able to provide estate planning advice for where those two topics meet and sometimes run head on into each other. So let's hop into it. I'm going to talk at you for about an hour. As Nina said, little weird for me to be speaking into a camera with no human faces on the other side. In real life, I can at least see if there's one person in the back laughing at my corny jokes. So here I'm just going to have to trust that you guys are laughing at said corny jokes. And at the end, hopefully there'll be some Q&As to show me that this was interesting and at least one person was awake while I was talking. So I thought we would take this kind of in the natural progression of life, right? So if we're talking about the possibility of divorce, typically we start with, hey, I might get married. Hey, I did get married. Hey, now I've got to be married for a while. Uh-oh, I think maybe I'm going to get divorced. I am actually definitely going to get divorced. And then, oh, holy day, I have finally signed the paperwork and I am free, right? So that's kind of the natural timeline of events. So the slides are going to generally follow that timeline, and we're going to talk about all the different things that we should be thinking about in our estate planning as it relates to divorce law and also vice versa. All right. So the first type of client we have, or it might even be you personally, is one who is thinking about, hey, maybe I might get married. That is a person who also might get divorced. Sorry to be Debbie Downer, but statistically, it's a true fact, right? Can't get divorced if you don't get married. And those who do get married sometimes get divorced. So what should we be doing if we or a client of ours is thinking about getting married in advance, in anticipation of the fact that a divorce could logically follow from that marriage? The obvious answer to this is prenups. Everybody knows what a prenup is. I'm sure I could have taken raised hands from the audience and someone would have shouted out prenup immediately. Prenups are great. We should absolutely be doing prenups for especially our high net worth or ultra high net worth clients. But by themselves, prenups are rarely enough for our wealthier clients. The reason for that is a few different things. One, and I don't know if anyone has let you in on this little secret, but there's no such thing as a written in stone prenup, the end, goodbye, end of story. We're not even going to talk about this, right? Most divorces, in fact, I believe the statistic is over 99% of divorces settle. They do not go to trial. The only way a judge is going to enforce a prenup is if you were in a trial in front of said judge. And so prenups are great to have in your back pocket. They certainly give you a much better bargaining position. They are enforceable, and so that will impact the negotiations, but we shouldn't trick our clients into thinking, or mislead, that's a better word, mislead our clients into thinking that just signing a prenup is enough. Because I can promise you that the terms of that prenup are going to come into the settlement discussions, and whoever wishes there wasn't a prenup is going to try to poke holes in that in some way, shape, or form or another. Lots of ways to do that, right? I signed the prenup under duress. It was signed too close to my wedding. What choice did I have? The other party did not fully disclose all of the information he or she had, and therefore the prenup should be set aside, right? So lots of different arguments that might chip away at the protections that a prenup provides. So again, super important, but not the end of the story. For our high net worth clients, in addition to the prenup, what we want to be using are certain estate planning techniques to ensure that assets cannot be commingled in a marriage. Okay, so stick with me here. Few things are considered non-marital property. Things like assets you bring to the marriage. Technically speaking, you don't even have to sign a prenup. That's your separate property in most states, at least in the United States, except that most people do a terrible job of keeping the property separate, right? Same with an inheritance. If you get $10 million from great Aunt Gertrude, technically that inheritance is separate property, not subject to equitable distribution at the time of a divorce. People mess it up all the time. The other thing to keep in mind is that the burden in most states of proving the property is separate property, aka not marital property, is on the party asserting that. So that means that the default, absent proof, is that it's marital property. And so you're fighting an uphill battle. What do we do in those types of situations? In those situations, we utilize different types of trusts that can own assets and therefore make it impossible for them to be commingled, right? So if my irrevocable trust owns the home that I came to the marriage with, there's absolutely no argument that I, the person, commingled that house in the marriage because I don't own it. The trust owns it. The trust has a separate tax ID number. The trust files its own income tax returns if there's any income, right? Might not be if it's your house you're living in. Those types of structures ensure that property cannot be commingled and there is literally no argument to be had, right? And that takes away that horrible burden of you having to go back in time on your personal account statements or your personal deeds or records and showing that it was separate property. We know it's separate because it's not even owned by one of the parties to the divorce. It's owned by this trust, which is a separate entity. The other thing that I always counsel clients on prior to a marriage is making sure that they have access to full information. What's a great example of that? Let's say you're marrying into the wealthy family and you know that there's a bunch of trusts and different entities out there, maybe family partnerships, LLCs, trusts owned by trusts, LLCs owned by trusts that are owned by other trusts that are owned partially by who knows what, right? Having the information as to what is out there from the outset when the relationship is good and you can ask questions and maybe get truthful answers back is key. Becomes incredibly important if there are children of the marriage later. So most of our estate planning techniques utilize terms in a trust that provide for the descendants of a beneficiary. So let's use my example again. I'm marrying into a wealthy family. Who we want to pick on today? Maybe I'll jump right into Bill Gates. All right, I'm old school, so Bill Gates is still my example of a super rich dude. I know Jeff Bezos has more money, but I don't know. I like Bill. Okay. I feel like he's real smart. So let's say I decide that in spite of everything I've heard Melinda saying, I'm going to jump right into the whole Bill Gates situation. In that case, Bill might have trusts for his benefit. And the question is, do those trusts say that it's just for the benefit of Bill? Or does the trust say that it's there for the benefit of Bill and Bill's descendants? Because who might be creating some of Bill's future descendants? This girl, right? And so I would want to know if my children, who I would theoretically then be the guardian for later, have a right to distributions, have a right to information, have a right to demand things from the trustee of these trusts or the manager of the family partnership, etc. So collecting that information early when we're happy and in love and feeling good, always a good idea. Okay, so let's assume we fast forward and that phase of life is over. And now we're not feeling so great about our relationship with old Bill, right? Poor Bill. He's getting picked on a lot today. Not fair. He should have to go through a second divorce so quickly, but we're going to use it as our example. So I've decided now that I'm not feeling so hot about Bill. And I haven't filed for divorce yet. I maybe have started talking to people. Maybe I'm asking my friends who've been divorced. Maybe I'm calling my estate planning attorney. Maybe I'm talking to some divorce attorneys. But I'm starting to prepare and figure out what do I want to do. Now, there's a key distinction here. And if I had a family law attorney on here, they'd be raising their hand or their hair would be on fire. And they would say, well, Stacy, you cannot advise clients to do divorce planning. Most courts in the country will set aside anything that appears to be or can be proven to be divorce planning. Divorce planning is 2 days before I filed for divorce, I transferred $3 million to Susie Q, and Susie Q is my new girlfriend, we find out later, right? That's a couple things. That's divorce planning. That's dissipation of marital assets. That's got a lot of problems on it, right? And so our question always is, what is estate planning versus what is divorce planning? I'm going to talk about all of this planning as if it's estate planning. So I am assuming that there is a legitimate reason outside of the divorce that we're going to do this planning. I'm assuming we're going to do it well in advance. I can't help you if you come to me 3 days before you're going to file for divorce, or your spouse has already filed for divorce and now you're scrambling. And I'm going to assume that you are not, by doing the planning, you are not leaving your soon-to-be ex-spouse completely destitute, right? Anytime someone tried to essentially bankrupt the marital estate, that's not going to work, right? No court in the land is going to let you hide all of the money in these trusts and fancy mechanisms and leave your ex with nothing. But we may be able to do some planning that mitigates some of the issues you're going to come up to in divorce. And so I like to call it dual purpose, right? It's estate planning that has its own reason and rationale, but it might also help you in your divorce. Okay. I'm sure there are some family law attorneys out there who would say that's too cute, Stace. So certainly consult with your family attorney before you do any of this. But these are the creative ideas that I've talked with my clients about. The first is simple, right? Consider whether you want to update some of your beneficiary designations. This is easy. You don't even have to come to me to do that. You can update your beneficiary designations usually right on the good old internet, right? You log into your account, there's some tab in the left corner you click, and there's a bunch of things you can pick from, and it says update beneficiary designations. You push a bunch of buttons and submit. That's something you will not be allowed to do, at least in any state that I'm aware of, once someone has filed for divorce. Now, again, you can get too cute here. We're not going to update our beneficiary designation and name our new girlfriend. That's a bad idea. But if you wanted to change your beneficiary designation on your life insurance from your spouse to your life insurance trust, that would be a good time to do that. If you perhaps thought, well, you know what, if I kick the bucket tomorrow, my spouse doesn't really need the life insurance proceeds. I'd rather that go to my children or my grandchildren. That would be a good time to update that beneficiary designation either directly to your children or hopefully better to trust for the benefit of your children, right? The other thing you want to do as soon as that divorce bell is going off is sit down and analyze the assets of the marriage, and even those we're going to argue are outside of the marriage, and see what the status quo is. Status quo is a huge concept within the family law division, right? You hear it all the time. The judges order that the parties keep the status quo. We're going to keep the status quo, keep the status quo. That means whatever you got, you're going to be stuck with it. And that might be fine, right? You might sit down and look at how the assets are titled and everything's joint and we're feeling good about that. And maybe our client isn't high net worth enough to have trust, so we don't really need to read through a bunch of trust agreements. Okay. Or maybe we sit down and we look and we say, okay, not ideal that the only person who's on this account is my soon-to-be ex, and that'll be the only person who can get information. I want to add myself onto the account now. Now, you need consent of your spouse, right, to do that. So I understand there could be practical limitations depending on how the relationship has broken down at this point. Another example would be a detailed review of the trust that you have in existence. So many estate planning trusts have different powers within them that either the grantor or the spouse or the trustee, if one of you is the trustee, are able to exercise. We should be looking at those powers and seeing, hey, is there a reason to be doing any of these? Let me give you a great example. Let's say you have set up an irrevocable trust for the benefit of your spouse and children, and even though Stacy advised you not to, you decided to name your spouse as the trustee. It might be time to change that decision, right? Now, again, I would have advised you never to do that to start with. So that's not just a divorce planning thing. There is a good estate planning reason, and we can do a whole presentation later on this, about why we would name a professional, disinterested, third-party trustee instead of a spouse, instead of your brother, instead of Joe the plumber down the street, right? And so taking a look at those types of things, pre-filing can give you a lot of options that you're not going to have as readily available to you later. Okay? I do also have some clients who in the dark of night sign new estate planning documents. There's no requirement that your estate planning documents name your spouse as the sole beneficiary. Most states do have some kind of statute that doesn't allow you to completely write out a spouse, sometimes called an elective share. Other states have different setups. So keep that in mind. But generally speaking, you can set up your estate plan, one, without informing your spouse, and two, in such a way that either your spouse does not inherit everything and or isn't in control. So even if I was going to leave assets to my spouse, I might change it so that those assets go into trust. And the trustee of that trust is somebody that pun intended, that I trust, right? Perhaps it's a professional again. That's what I would recommend. But it certainly shouldn't be your soon-to-be ex-spouse's sister, right? That's a bad idea. We don't want to have that in place in case something happens to you in the interim of the divorce. I will also tell you, as a side note, I know that in New Jersey and New York, where I primarily practice and see all of this fun stuff, that there's been a lot of talk about what happens when someone dies in the middle of a divorce. Um, why is that a new topic, you might wonder? My theory is that because divorces now take ungodly amounts of time, right? Used to be you'd file for divorce. It might take you, I don't know, 8 months to a year from start to finish. If you can get out of a divorce proceeding in a year, you give me a call, because I haven't seen it happen in a very long time. So statistically speaking, the longer the divorce goes on for, the greater the likelihood that someone's going to die in the middle. And so I think the courts have been seeing more and more folks pass away in the middle of their divorce. And then they're like, uh-oh, now what? So just be aware of that in whatever jurisdiction that you're in. Again, I know in New Jersey, we have a brand new spanking law for that. And I would assume that probably a lot of other states are not too far behind. Little things that you can think of. Again, no one's filed for divorce yet. We're still in that phase. Little things you can think of in your planning, whether or not the divorce is imminent, right? So I always say divorce is possible. Again, I said this in the beginning, for any person who is married. And so these types of concepts should be built into your estate planning documents if you're married at all. I don't care if you think you have the most magical marriage of all time and divorce is never a possibility for you. You should still be thinking about this. It's good luck, right? I always say it's like if you bring an umbrella, it doesn't rain. So if you plan for divorce, greater likelihood that it doesn't happen. I can't prove that. That's just an old wives' tale in my head that I created. But it makes people feel better. So let's say it's true, because there's no one here to disprove us otherwise. So things that should be built into your estate planning documents. Now, you might say to yourself, if you're not an estate planner, well, shouldn't the estate planning attorney be thinking about this? Heck to the yeah is the answer. Of course, they should be thinking about this. This should already be built into whatever forms or templates or past examples that they use to build and create your estate plan. But you heard me say in the beginning, most estate planning attorneys have very little exposure to the family law world. They're uncomfortable with it because they don't understand it or how it works. It is a very different area of the law from anything else, right? I love to call it the Wild West, because there's rules, but like, are there rules? Like any rule that exists, the judge can say, well, this is a court of equity, though. And so I have determined that following the rule wouldn't be equitable. So I'm going to do the opposite of the rule. And so if the ability to use the word equity to change the rules exists at any time, are there even rules? I'm not sure. So that makes other attorneys very uncomfortable, right? We like rules. If you litigate in any other area, I do a lot of litigation in the trust and estate space. We got rules, man. And we like our rules. They keep us honest. They make us comfortable. We get real uncomfortable when we're in a land where there are fewer rules and we're just kind of thinking out loud about what might be fair. So what should be in those documents, right? The first most important thing, bullet number 1 right here. If you learn nothing else and you're an estate planner on this call today, look at your documents and look at how you're defining the term spouse. For how long is a person a spouse within whatever document that you're creating, right? For most irrevocable trusts, the vast, vast, vast majority, once parties are divorced, then the spouse ceases to be deemed a spouse. Kind of makes sense since you're not a spouse anymore, right? But the question is, what point in time does that event occur? Now, I would argue that the best practice is that that event occurs much earlier than what I see in most documents, right? So when I review other people's trusts, the most common example I see is that you cease to be a spouse if you die. Okay, well, duh. You can't be a beneficiary if you're dead. Or you cease to be a spouse when a divorce is finalized. finalized. I just told you that it could take 3 to 5 years. I have a client right now who's in his 5th year of his divorce. So for those 5 years, if he had this definition, his soon-to-be ex-spouse would still be considered a spouse in his irrevocable trust, would still be a beneficiary of those trusts, could still demand distributions from the trustee of that trust. And I can promise you that that is not what the client would have wanted, right? Client contributed funds to this trust for the benefit of his spouse for so long as he considered her his spouse. On the day he filed, he didn't see her as his spouse anymore. I can promise you that. So my best practice, I define it to be the earlier of filing, separation agreement, the parties live separate and apart for a certain amount of time, or somebody's dead, right? You also want to look at, I'm sorry, you guys, if I cough a lot today. My young children like to sneeze in my face and give me their colds. So on the uphill swing, but I'm still having to drink water when I talk a lot for an hour straight, as an example. The quality of funding and trust and titling assets, not a great thing for your client if he or she has none of the assets in their name. Now, a court of equity will step in, of course. They will make sure that that spouse gets some money eventually. The question is, how long does it take to get to eventually? So you don't want to be in a situation where your client is asking the court to make the other person turn money over. Be much better off if you've already got assets titled in your name. Same with trust assets. We don't want to have a situation where one spouse has access to trust assets and the other does not, or where one spouse has used up their exception and the other has not. We really want to be thinking about, are we doing this planning in an equal fashion? Or if we're not doing it in an equal fashion, is there a good reason for that? And there might be, right? You might just represent one spouse and they might say, well, I don't want it to be equal. That's fine. But just make sure that you're thinking through that concept as you're doing planning so that you don't find yourself in a situation where you've done something for the client that doesn't really meet their needs or what they were expecting. I also cannot emphasize enough the importance of having third-party disinterested trustees. I speak on this topic a lot also, so if you want to search me up on the internet, I'm sure you can find an example where I spend a whole hour talking about why it is so important to have a professional trustee in place. But in the context of divorce, couldn't be more important. Again, you're going to have the spouse who, we'll say, loses out on the trust assets, arguing that the trust is a sham. And we're going to talk later a little bit about the different arguments people make to try to attack these estate planning techniques during a divorce. But they're going to stand on their soapbox and they are going to yell and scream and they're going to say, Your Honor, this trust is a sham. It's not real. My spouse did this just to divorce plan, the dirty word that Stacy said we cannot use, and purposefully set it up so that he or she has access, has control. I have nothing, right? That argument doesn't go very far if you have a disinterested third-party professional trustee in place. So many of my clients select me in that role. Not all attorneys will serve as a professional trustee. In fact, I think it's more and more rare. And so in those situations, very difficult for a spouse to claim that I am somehow biased when I serve in this role for hundreds of folks, and am able to do that in a professional way, right? You would have to show something really crazy for a judge to think that I'm somehow involved in someone's personal divorce vendetta, right? Not going to happen. Okay, so we're on our timeline of events, and now let's assume that someone has finally filed for divorce. And remember, for lots of folks, this takes a long time, right? Sometimes there's an event that happens and somebody files for divorce very quickly thereafter. But a lot of times there's a lot of hemming and hawing that goes on. One party really isn't committed to the marriage, but can't decide whether they want to just stay or whether they want to go through the pain, hassle, and uncomfortableness of a divorce. And so sometimes we can be in that pre-stage for a really long time. And the longer we're in that pre-filing stage, the more opportunity there is for divorce, for planning that helps you in your divorce that isn't divorce planning. But let's assume now we move forward and someone finally was like, you know what, enough is enough. I'm going to hire one of these family law attorneys Stacy keeps talking about. Now I'm going to file and start the clock on this divorce. Once that happens, again, remember, we are going to be stuck with the status quo. Very few things you can change, except I'm going to say if we have separate standalone entities like our irrevocable trusts, where we may be able to exercise some powers there. But generally speaking, once someone is filed for divorce, both parties are going to be stuck with the status quo. So the planning opportunities are few and far between. What do we need to be talking about with our clients and thinking about as practitioners once that happens? So the first thing is, I cannot emphasize this enough. You have to assemble your team early and get them in the loop. Now, every client, and maybe you personally, if any of you have been through a divorce, starts out a divorce in the same mental space. There are two mental spaces you start out divorces in. Now, I mean, I can't prove any of this either, you guys, but this is my opinion. You either go into a divorce saying, I just want to be reasonable and get out of this as quickly as possible. That's usually the person who has processed correctly and has instituted the divorce. And the other mental space is, I cannot believe this person is doing this to me and I will burn his or her world down. Fun, right? So those are the two mental spaces you can be in. If you're both in the first one, I just want to do what's fair and I want to get this done promptly and quickly and move on with my life. God bless you. You have what's called the dream divorce. I don't have statistics on this, but I would estimate it's maybe 5%, probably way less. And those that start out in that space often deteriorate into the other space that I was talking about. As soon as you have one or both spouses saying, I want to be difficult, I want to punish, I want to hold this person accountable, then you're going to be in it for the long haul and for a fight. For our ultra high net worth clients, incredibly important to get the team assembled first thing so that we can set the parameters of what that fight's going to look like. We don't want to wait until halfway through, 2/3 through, almost at the end to get the other professionals involved, because by then it's going to be too late to shape our story, to shape our strategy, and we're going to leave planning opportunities on the table that we could have really used to help the client. I'll give you a great example. This is my favorite example. I was close, professional friends, we'll say, right, with a family law attorney who didn't have a particularly sophisticated client base. And so we didn't share clients. We just knew each other professionally and tended to get along. And so one day she called me, I think left a voicemail and said, like, I need a quick favor. Can you call me back? And being the diligent and organized attorney that I am, I called back the same day. And I said, hey, what's up? And she said, I'm working on settling this case and we're hoping to sign the MSA tomorrow. But I was wondering if you could tell me what this trust is. Now, spoiler alert, it's too late. I could tell you that this trust has like the Hope Diamond and I don't know, half of the continent of Asia in it. And it's not going to do you any good. It's too late. You've already agreed to the basic terms of what this MSA is going to say. You've already been negotiating for months without the benefit of knowing, does this trust help you or does this trust hurt you? Does this trust impact what your client's getting? She didn't even know. And so it's my favorite example because, one, I think she really exposed herself to malpractice, right? She knew there was a trust, right? She can't claim she didn't know there was a trust, but didn't do the work that needed to be done to understand what it said, what it meant for her client, and how it impacted the divorce. And of course, I can't help her one day in advance. I think I did tell her what type of trust it was, and that I thought that she should perhaps look into it further. And that was the end of the conversation, right? I think obviously she was looking for me to say, I don't worry about that. But that's not right. You do have to worry about that. Other great examples, right, of who should be on the team. You got to have a great accountant. You got to have a great financial advisor. You can't advise your client to take an asset that has negative income tax implications later and agree to let the spouse take an asset that doesn't have those same implications. So the estate tax consequences, the income tax consequences, and then also I'll call it like the financial advising analysis on assets is so incredibly important in analyzing whether you are getting your client the best deal that you can. So the sooner you can assemble that team, get them in place, get them all on the same page, moving forward with a streamlined strategy, the better job you will do for your client. Now, I know what you guys are all thinking. I can hear you. You're thinking, well, that's great, Stace, if the client has $100 million, because they'll just be shelling out money like it's nothing. They don't care if they hire 5 lawyers. But for my more, like, we'll call it like middle of the road, please don't judge me that I'm about to say middle of the road is a few million to 20 million, right? I get it. Most of America has less than that. That's not what we're talking about here, though, right? If you've got $1 million and up, let's say, you most likely have some kind of trust in place, at least some estate planning concerns, for sure some assets that are being managed and have different tax treatments. So depending on the net worth and complexity of the client, that impacts what kind of team you have to assemble. But if you're not asking yourself that question on day one, you've done something wrong. In terms of cost, how do I convince my client that this is worth the cost? If you need horror stories, you call me. I'll come up with 1,000 of them. But I think it's showing the value, right? If we get these professionals involved quick in the beginning and get our analysis under our belt, we can come up with a better game plan that's going to save you money in the long run. That's the pitch. Okay, so let's assume we've done what I call the hard parts, right? We've filed, we've done discovery, we've arm wrestled over who gets the dog, right? We're ready to start drafting up our final agreement. I'm referring to it as an MSA, a marital settlement agreement. I've seen people call it a property settlement agreement. I suppose you could call it a divorce agreement. I don't care what you call it. Same thing. The contract that 2 of you sign at the end of the marriage that says, here's how we're going to break this partnership up. Because that's really what the law treats a marriage as, a partnership that's hard to escape from. That part I added myself. So what are some key terms you want to be thinking about in your MSA as it relates to estate planning, right? And this is where I see the family law attorneys who perhaps aren't as used to dealing with ultra high net worth clients, or perhaps aren't as knowledgeable in the estate planning field. This is where they kind of fall short, right? They might have this stuff in their forms, but it's probably there just because it's always been there. They don't really understand what it means, maybe. They haven't thought through all the ways that it could be good or bad for the client. And so this is one of the places where you really want to get your estate planning attorney involved. Even if you have a client who isn't high net worth enough to justify the full-blown team from the beginning, good idea to have the estate planning attorney bill what? 2 to 3 hours to take a look at the MSA and point out any estate planning problems they might see. Couple examples to aid you in that quest. First thing I see that is wrong all the time, drives me bonkers, like lights my hair on fire, start pulling out my eyelashes. I read an MSA and it says the husband shall be required to obtain life insurance. Okay, I'm with you so far. And name a trustee. Well, what does that mean? And then I'll ask the family law attorney, like, trustee of what? You can't just stand on the mountains and say, I hereby declare a trustee. You need a trust agreement. There's no trustee if there's no trust agreement. And if you haven't said what the trust agreement has to say, what have you said? And does the trust have to own the policy or just be the beneficiary of the policy? Makes a big difference. And here's why it matters, you guys, because I just mentioned earlier on that you can update beneficiary designations in the snap of a finger. And so let's say your ex-spouse is required to hold $2 million of life insurance and name you as the beneficiary. How can you hold that person accountable for that? Now, my family law attorneys are going to say, well, we came up with a solution for that, Stace. Great news. In this agreement, it says that the husband, in my example, has to prove twice a year that the wife is the beneficiary. But I just said you can change the beneficiary with the click of a mouse. So you mean that twice a year, the wife is a beneficiary for long enough for him to print out the piece of paper that says she is, and then he could go right in there and undo that for the rest of the month. So the only time that she's the beneficiary is for the 1.5 minutes that it takes him to print out the form and email it to you. I would say you have not given that client much protection. By contrast, if there's a requirement that the life insurance be owned by a life insurance trust, now the owner is the trustee. And I would argue again that your trustee should most likely be a professional, disinterested third-party trustee. And that person is the only person who has the legal authority to change the beneficiary, right? And now what have you done? Now you've taken something that's going to plague your client for years, where she has no protections, no assurances, and turned it into something that's rock solid, she can count on, and we know we don't have to come back to. So is it more expensive because you got to draft a trust? Yes. But now you don't have to pay your family law attorney to follow up twice a year for the rest of time to do what? I don't know, nothing. Right? Great example. Other things that I've seen folks incorporate into their MSA related to estate planning: who could be the guardian of the kids, right? Who can serve as trustee for the kids, how we're going to leave assets to the kids. Are we going to require that these children be beneficiaries of your estate and your trust that you've set up? Or can you write them out and leave everything to your new child with the new girlfriend, right? All of those types of things can be built into MSAs. Many clients don't go that far, right? They maybe don't want to agree. They may not want to agree to that, right? Either party might have new children and want to change how they're going to leave assets. They may want to be able to hold their children accountable. I happen to be a big fan of that, right? If you have one child who disowns you and is a real jerk face, I don't know why I should need to name them as a beneficiary of my estate, right? So these are things that you should talk through with your client, and they should understand what they're agreeing to, but different answers might apply for different folks. Keep in mind that if you don't contract for those kinds of things in your MSA, that your spouse, ex-spouse, soon to be ex-spouse, because we haven't signed the MSA yet, we're still negotiating it, soon to be ex-spouse has a lot of power to do what they want on their own side of the equation. And here's the big one: what happens if you get hit by the asteroid and depart the earth? That surviving parent for your minor children is going to hold all of the cards, unless you've built in trusts with independent third-party trustees. There I am on my soapbox again, right? We want to make sure that there's someone else watching if, God forbid, something happens to you, right? And the same with the terms of the MSA. An MSA isn't magical, right? There's no trust police or MSA police out there with sticks hitting people saying, hey, you have to follow the terms of this MSA. The only person who makes sure your ex-spouse follows the MSA is you. And so if you are no longer here, there's nobody to step into your shoes unless you've thought about that and put in other parties who can step in and make sure that especially your minor children, but perhaps even adult children, are protected in the event that you're no longer here to do that for them. Also, any kind of solution we come up with for our clients, we have to be thinking about, what does it take to enforce this, right? So again, no MSA police with sticks. Just writing it on a piece of paper and both signing it doesn't do squat. We have to think through, what would we do if one party is like, I'm not doing it, right? And how do we enforce those things? The life insurance is a great example. If the MSA just says that he's got to prove he's got the life insurance, that doesn't help us. We can't enforce that in a real way, right? So we've got to be thinking about through those issues as we're drafting MSAs. I'm going to skip this slide because I think I beat the life insurance thing to death. But this is the most common thing we see for regular folk, right? Our ultra high net worth clients have this issue plus a bajillion other issues. But even your most regular couple who doesn't have millions and millions, this is the big thing that you want to be thinking about as you're drafting their MSA and trying to protect everybody with the life insurance that's in place. Okay, so this is my favorite part to talk about. Where does Stacy and her team and other people like me across the country who do this kind of work get involved? When do we get pulled in? on divorce matters, right? Now, I just said that the best idea is to hire us right in the beginning as part of the team and have us consult, blah, 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 blah. Yes, that's the best way to do it. How many people actually do that? I don't know. It's pretty rare, you guys. Usually, I get the call once we're fighting, right? And I get real excited. I'm like, all right, send me copies of the trust. What's going on? Who's being a jerk? Who's being cooperative? What's our status quo limitations? Where are we? And so we are seeing more and more litigation, again, mostly for high net worth or ultra high net worth clients when it comes to trusts in divorce. There is a lot of new case law on this nationwide. I'm going to give you the case that's in New Jersey, which you could shepherdize and see other cases that are similar in other states if you're so inclined. So in New Jersey, the case that addressed irrevocable trusts within a divorce is called Tannen v. Tannen, Tannen. And in Tannen v. Tannen, essentially, the wife, I believe, had a trust, and they said the trust wasn't going to count. That's the short answer. Now, when you really read the case, being the legal scholars that you are, you're going to say, well, hold on. This case didn't say trusts are out. It said in this very narrow, limited situation where these were the terms of the trust, and this was the situation, that in that case, the trust assets couldn't be considered for equitable distribution, child support, or alimony. And I would say to you, you are correct in your legal analysis. Bravo to you. However, what Tannen has come to mean in the New Jersey family courts system is that trusts are just out, right? So I will tell you, I don't know that if even my smartest favorite colleagues in the family law world would be able to explain to you how to distinguish Tannen from a different type of trust, right? We're talking about very specific trust knowledge and expertise to understand how you might be able to say your trust was different from the Tannen trust. So what that means, at least in practice and until we have some more case law in our state, is that most family law attorneys say, okay, if a trust is here, it's out, right? But guess what? We don't just all agree to that. We're going to fight over it, right? And so when we look at trusts, there's a few key things we want to look at. So the first issue I see is that a lot of family law attorneys don't understand that a trust is a separate entity. Now, there are some kinds of trusts that may not be separate entities, but the vast majority you're going to run into are irrevocable trusts with their own tax ID number that are separate and distinct not individuals, entities. There's the word I'm looking for. Separate entities. And so if you want to try to get to that trust or assets in that trust, to put it a better way, technically speaking, I think you would have to add the trust as an interested party in your divorce proceeding. And if you do that, that means you're adding the trustee, who hopefully is a disinterested third-party trustee. You guessed it. That trustee is then going to turn around and say, hold on, if this is going to impact the trust, we need all the interested parties of the trust. So every beneficiary of this trust needs to be added to the divorce proceeding as well. You can imagine how hairy that gets, how fast. And so divorce courts on the whole nationwide are shying away from that concept and saying that absent some kind of divorce planning red flag, those trusts are not going to be considered in part of the divorce proceeding, whether it's in equitable distribution, whether it's in child support, whether it's in alimony calculations. Now, there's some workarounds, right? I mentioned family law courts at courts of equity. And so how do they get around that, right? How do they make things fair, which is what they want it fair, whatever that means, right? Without adding the trust as an interested party. So sometimes the argument will be that there was a dissolution of marital assets. So let's say, we'll pick on Bill again. Let's say my hubby Bill takes $20 million and puts it into a trust, and he doesn't tell me. Okay. Or maybe he told me, but he put some paperwork in front of me. I just signed it and I said, oh, little old me, I didn't know anything about trusts, right? In that case, the argument's could be fraud, could be maybe duress even, like he made me sign these. And ultimately, the argument is that there's been a dissolution of marital assets. Not that we should claw the trust assets back, because again, we'd have to add the trust as an interested party and all the beneficiaries as interested parties to do that, but that I should get a bigger piece of the pie that's left because my hubby Bill gave away a bunch of money without my consent or approval, right? Just like if he wrote a check for $20 million to his new girlfriend, I'd be able to claim dissolution of marital assets. That is probably, I would argue, the best argument people are making to equalize themselves for this trust planning. But the reality is most of these trusts are funded for the kids. Most people don't fund these kinds of trusts in anticipation of divorce. They do it because they're so stinky wealthy that they want to set aside for estate tax planning and income tax planning purposes a big chunk of money for the future generations. And then once the divorce comes along, one spouse has the regrets about that decision and wants to undo it, right? So the key in settling these kinds of cases with these types of trusts is to understand that backdrop and to really understand the terms of the trust. And you got to read all the boilerplate, you guys. I'm sorry. It's going to be boring. Maybe do it with a little wine or something. I don't know. I had one case, which was really fun, where the key to settling the case was that the drafting attorney, who wasn't me, praise the Lord, defined spouse differently in the two trusts. So one spouse stayed a beneficiary after the divorce and the other spouse didn't, which, oh man, I hope that guy didn't get sued for malpractice, but gave one side a really good bargaining chip, which ultimately led to the resolution of the case. But I wouldn't have found that if I hadn't read through every word, even in the definitions section, which is a bummer, but you got to do it. Okay, real quick, and then I'm going to go to questions. Obviously, once your divorce is over, I hope this is obvious. You got to have new documents. You got to sit down again. You got to redo everything. Your whole life just changed the same way. If you magically got $100 million, you got to sit down and redo everything. You've now just lost a big chunk. Sorry, because you split it with another person. You're now single. You might have kids, et cetera, et cetera. You got to sit down and redo your documents. Really hard for a lot of clients because they have what I like to call lawyer fatigue. They've been paying a divorce attorney for, might be 5 years every month for 5 years with no end in sight. And the last thing they want to do is cut another lawyer check. But incredibly important to make sure your ducks are all in a row. Alrighty. So that leaves us just about 10 minutes exactly for Q&A. I'm going to stop sharing my screen so I can see the Q&A box. I can also give some more really exciting examples of the crazy stuff I've seen if we run out of questions, but it looks like we do have a few questions in the box. Okay, so first question. Would a revocable trust have the same effect to protect one's assets like an irrevocable trust in a divorce, or do you need to have an irrevocable trust to get the protection? Great answer. Great question. I'm about to give a great answer, I hope. It's not as good. It might work, but it might also totally do the opposite. So I actually have a real life example where we represented the wife of a professional sports player. That's as specific as I'm going to get in case I say something wrong by mistake that discloses who it is. Okay, sports player. He got a giant signing bonus of $4 million. He put it into his revocable trust. Okay, makes sense from an estate planning standpoint. Here's the rub, though. Would have been separate property, except, because I believe he got the bonus before they were married, except that in his revocable trust, his wife was a beneficiary, which makes sense because while they were married, why would she be a beneficiary, right? And so then we argued that he commingled it in the marriage by naming her a beneficiary, and we won that argument. So revocable trusts might help, but you got to be real careful about how they're crafted. If I have a client who's run out of time for a prenup, right, you're really not supposed to do prenups on the eve of a marriage because then we see them as kind of icky and, of course, we'll throw them out. What we'll use instead is a revocable trust that owns assets, but we have to be very careful that the spouse or soon-to-be spouse is not a beneficiary of that trust. So it can work, but you got to be careful. Next question. In highly litigated divorces involving irrevocable trusts, what arguments have been most persuasive in overcoming claims of fraudulent conveyance or improper funding? Ooh, great question. And listen, this is absolutely how I'm advising clients, right? You can't be doing this in the dead of night with no notice whatsoever and think that if you get divorced in a year, your wife or husband is not going to attack this transfer. So what are some key things we want them to be doing? Ideally, the other spouse is involved from day one, right? He or she attends the meetings, right? We'll use, it's so hard to use both genders. So we'll say it's me and Bill again, okay? Bill should bring me to the meetings. He should make sure there's a record of the fact that I was at the meetings. I should sign stuff like the trust agreement, like the transfer of assets, like the gift tax returns, reporting the gifts. The more involvement you can prove of the non-moneyed spouse, the better off you'll be in the event that someone's trying to attack those trusts. And then, as I already mentioned, I think the most important thing you're going to do is pick the right trustee. Bill should not pick his brother. He should not pick his bowling buddy. He should pick someone who does this for a living, who will make it clear to the courts and everyone involved that they are not biased. They're not just a shadow puppet for Bill. This is a job. They're doing the job, and they're following the requirements of the trust agreement. Next question. How do you balance ethical obligations when a client wants to revise estate planning documents mid-divorce without tipping off the opposing party? Oh, great question. You can't. So if you jointly represent both spouses, you cannot do that. And in fact, when one of my clients calls and says, Stacy, and I represent both spouses, says, Stacy, I'm getting a divorce, I say, shut up, stop talking. I cannot talk to you about this. I jointly represent you and your spouse. Anything you say to me after I complete this sentence, I am required by law to disclose to the other party. So if you need other names of individuals you should call, I'm happy to give you other names, but I cannot talk to you about this. Sometimes you can come back around on the back end. So what I typically do once I know that there's a conflict, because that's a joint representation with a conflict, is I terminate the engagement. And you don't have to say why, right? Unless they both know they're getting divorced, then I guess you can say why you're getting divorced. It's an unwaivable conflict, and so I need to terminate this joint representation. After the divorce is complete, or if at any time you feel that the conflict has resolved, you could come back in for one spouse. Or actually, theoretically, if the divorce is completely finalized, I think they could both hire you separately, because now their finances really have nothing to do with each other. But you got to be real careful about how you're addressing that. And if you're in a sticky situation, if in doubt, get out of it, not worth it, and or talk to one of our friends who does this thing for a living and get some advice. Next question. We got a couple more minutes. What drafting techniques have you found most effective in marital settlement agreements to prevent later disputes about life insurance obligations? Yeah, so you should, like I said, not just say the word trustee, like trustee, and think it works. No, you have to draft a trust agreement. Ideally, you draft it in advance and it's signed and dated and you can reference it in the MSA. If your clients aren't as diligent and ahead of the game, then you say they're going to execute a trust agreement, and a version of what that's going to look like is attached as Schedule Exhibit A, right? And whatever they eventually enter into is going to materially conform to whatever I've attached as an exhibit to the MSA. Great question. What remedies have you used when a client fails to change beneficiary designations post-divorce and the ex-spouse later claims the asset? Ooh, that's a fun one. Most states in the U.S. have a statute that address that. So in both New York and New Jersey, I can tell you there's a statute that says once you've been divorced, we will presumptively assume that the decedent intended to revoke that, unless, of course, they do it after the divorce. Then we'll undo that assumption. So usually you can get rid of that, but you got to go to court for that. It's like a whole thing, right? Much easier to just update the beneficiary designation. So do that instead. Much easier. Have you encountered resistance from probate courts in honoring divorce-related restrictions or provisions once the estate plan is probated post-death? That one you're going to have to email me later, because we're about out of time and I'm not sure I understand your question, because most divorce-related restrictions would no longer be particularly relevant once you've died, unless you mean we got divorced first and then we died and we're trying to enforce something. But most likely, if we're enforcing the terms of the MSA, we're doing that in family court. So to give you an example, let's use the insurance that I keep talking about. If the decedent didn't do the insurance the way they should have, right? They put the wife's name for 30 seconds and then put their girlfriend. Really what that means is that the wife has a claim for breach of contract against the decedent, which she would file in probate court. You with me? And that would work, except if the estate's insolvent, right? So if it's a $5 million life insurance policy, as my grandmother says, you can't get blood from a rock. So if the probate estate has $5 million of assets, you're probably sitting pretty. You're going to get a judgment against that estate. He did have a contractual obligation to leave you the $5 million. He didn't do that. You're going to get a judgment against the estate. And if there's $5 million there, you'll be able to collect on the judgment. The problem is that for most of these folks, there isn't $5 million in the estate. And therefore, you're kind of left with a judgment that you can never enforce. And so, like, you won, but it's not very exciting. Next question, can one appoint their child to be a holder of a trust with specific details for them managing the trust after adulthood? Yeah. But again, no trust police with a stick. So who's going to make sure that they do what you told them to do? The only person who can enforce that is a beneficiary of the trust. So really, you're kind of relying on your kids, so your grandchildren, to sue their parent if they don't do what they were supposed to do in the trust. I don't think that's particularly realistic. It's also not a situation we want to put our family in. And a lot of times the mistakes, once they're made, you can't really undo the consequence, right? So if they do something, for instance, that includes the trust in their taxable estate, and you would, if you were alive, you'd be like, the whole reason I paid Stacy all this money to draft this trust was so that you wouldn't include it in your taxable estate, or you wouldn't include it in your marriage, and then you did it. Well, the law says, too bad. We're not going to undo it, right? The damage is done. Sure, the beneficiaries could sue you for messing it all up if kids want to sue mom, but it's too late, right? And so that's why I think it's so important, of one of many reasons, to have a professional trustee. Last question, right on time. Oftentimes I find that professional trustees will only handle trusts with a certain amount of assets in them. So how do you get around that issue with smaller clients? Yeah, you don't, is the short answer, right? So I can tell you that I think individual professional trustees have some more flexibility. So I don't have set minimums the same way a giant bank, I won't use any examples, but a giant bank would have. But of course I have a minimum fee that I'm willing to take on all that liability for. So if it's too small, you may not have the option of a professional trustee. I was kind of assuming that we were talking about a big enough number that somebody like a Stacy or big corporate trustee would want to be involved.
Thank you so much, Stacey, for that wonderful presentation and answering all of our audience questions. We really appreciate your insights. And thank you all so much for asking your questions. We really appreciate your participation. We want to thank you all so much for joining us for another Justia webinar. As I mentioned earlier, we have a great tool to enhance your professional presence, the Justia Lawyer Directory. If you haven't claimed your free profile yet, you can visit lawyers.justia.com to get started. Claiming your profile is free and easy, and we've just redesigned the directory with a fresh look and improved functionality, including new filters like top rated to help you be found more easily by prospective clients, as well as enhanced practice area FAQs to help visibility with AI-driven search results. And if you want to stand out even more, we also offer premium placements, platinum for top spots, and gold for priority listings, so you can get even more eyes on your profile. And you can learn more about those by going to marketing.justia.com. Thank you so much for joining, and have a wonderful rest of your day. Thanks for watching. We hope you enjoyed this video, and if you did enjoy it, please click the like button and subscribe to our channel for more videos on law practice and legal marketing. See you in our next video.